All names, places, and institutions are aliases used to protect privacy. Procedures and timelines reflect real-world law and forensics for immersion. The fluorescent lights in the post-conviction hearing room hum through the late afternoon, casting harsh shadows across rows of empty benches. Defendant Rook sits at the defense table, 23 years older than the day he was sentenced, his hands folded on legal briefs that have yellowed with time. Attorney North stands, one hand resting on a banker's box labeled State vs. Rook, evidence resubmission motion, the other holding a stapled lab report that arrived 6 weeks ago. Gallery noise, whispered speculation, the shuffle of reporters' notebooks, dies when Judge Keystone enters. Rook's chest tightens. In 90 minutes, the court will rule on whether a single buccal swab, preserved in a forgotten evidence locker for 2 decades, can undo everything the jury believed in 1998. The case always had one fact that never fit. The victim's watch had stopped at 9:47 p.m., yet the state's star witness placed Rook at the scene at 10:15, a timeline gap the prosecutor waved away as mechanical error. But the forensic analyst who examined the watch in 2022 found corrosion patterns consistent with water exposure and impact, suggesting the victim had been attacked earlier and somewhere else. That single inconsistency, dismissed as noise during trial, became the thread North pulled until the entire conviction unraveled. If you've ever wondered how a conviction that seemed airtight can collapse under scrutiny, stay with us. And if this deep dive into the mechanics of wrongful convictions resonates with you, leave a comment about which element of the case surprised you most, and subscribe for more forensic justice investigations. The original case began on a cold October morning in 2007, when a jogger found the body of Linden, a 31-year-old elementary school teacher, in a wooded strip behind Magnolia Park in the city of Riverbend. Population 70,000. Linden lay face down on matted leaves. Her jacket was torn, her purse missing, and a single stab wound penetrated her upper back. Time of death, based on rigor mortis and liver temperature, was estimated between 9 p.m. and midnight the previous night. The medical examiner, Dr. Vale, noted defensive wounds on Linden's forearms and traced blood smears on her palms, suggesting she had struggled. A canvas sneaker print was photographed in soft mud 2 meters from the body, a men's size 10, brand trail mark, a discount model sold at big box stores across 3 counties. Lead Detective Harbor faced immediate pressure. Linden was beloved in the community, and the mayor demanded updates by the week's end. Harbor canvassed the neighborhood and learned that Linden had left a school board meeting at 8:45 p.m., telling a colleague she was walking home, a 15-minute route that skirted the park's edge. Surveillance footage from a gas station 3 blocks away showed a figure matching Linden's build crossing the frame at 8:52 p.m. But no one else appeared in the shot. Harbor widened the search for witnesses and received a tip from a bartender at the Anchor Tavern, a dive 6 blocks from the park. The bartender recalled serving Rook, a 29-year-old maintenance worker with a prior misdemeanor theft conviction, until roughly 9:30 p.m., then seeing him leave on foot. Within 48 hours, Harbor brought Rook in for questioning. The interrogation lasted 11 hours, beginning at 6 a.m., and concluding after nightfall with no audio or video recording. Department policy at the time did not mandate it. Detective Harbor and his partner, Granite, alternated tactics. Granite offered coffee and sympathy, while Harbor pressed Rook on inconsistencies in his timeline. Rook admitted he had walked through Magnolia Park on his way home around 10 p.m., a route he took regularly, but insisted he saw nothing unusual. When Harbor confronted him with the sneaker print, Rook owned a pair of Trailmark shoes, size 10. Rook grew flustered and asked if he needed a lawyer. Harbor told him that requesting counsel would make him look guilty, a statement the defense would later argue was coercive and violated Miranda principles. By hour 9, exhausted and disoriented, Rook signed a statement acknowledging he had been in the park around the time the victim was there, a phrase the prosecution would later interpret as an admission of proximity and opportunity. The forensic case was thin. The sneaker print was a common model sold in 40 retail locations across Granite County alone. No DNA or fingerprints definitively linked Rook to Linden. The knife was never recovered. But the state's case hinged on the testimony of Jasper, a jailhouse informant awaiting sentencing on drug distribution charges. Jasper claimed that during a 48-hour overlap in the county lockup, Rook had confessed to him, describing the stabbing as an attempted robbery gone wrong. In exchange for his testimony, Jasper received a reduced sentence, 18 months instead of 5 years, a deal memorialized in a side agreement that the defense never saw. A classic Brady violation under constitutional discovery rules. At trial, prosecutor Slate framed the case as straightforward. Rook needed money, saw an opportunity when he encountered Linden in the park, and panicked when she fought back. Slate pointed to the sneaker print, the timeline overlap, and Jasper's devastating testimony, delivered with rehearsed precision on the stand. Public defender North, fresh out of law school and handling her first murder case, struggled against resource constraints. She had no funds for an independent forensic analyst and relied on cross-examination alone to poke holes in the state's narrative. She challenged Jasper's credibility, noting his incentive to lie, but could not produce records of the sentencing deal because Slate had not disclosed it. North also questioned Dr. Vale's timeline, noting that the 9 p.m. to midnight window was broad and that Rook's presence in the park at 10 p.m. did not necessarily place him there during the attack. But Vale stood firm, and the jury found his testimony authoritative. The defense's theory, that an unknown assailant had attacked Linden earlier in the evening, before Rook walked through the park, lacked physical evidence to support it. The jury deliberated for 3 days, during which they requested to rehear Jasper's testimony twice. On the third day, they returned a guilty verdict on charges of second-degree murder. Judge Keystone sentenced Rook to 30 years to life. As bailiffs led him away, Rook turned to his mother in the gallery and mouthed, "I didn't do it." She would repeat that phrase to reporters for the next 2 decades. Inside Granite County Correctional Facility, Rook's days settled into a rhythm of monotony and dread. He mopped floors in the laundry wing, attended parole board hearings every 3 years, each resulting in denial based on the violent nature of the offense, and missed his daughter's high school graduation, her wedding, and the birth of his first grandchild. His mother visited monthly until her death from cancer in 2016, always bringing photocopies of legal filings North had submitted on direct appeal. The appeal failed. The state appellate court found no reversible error, noting that the jury had been properly instructed on reasonable doubt, and that the evidence, though circumstantial, was sufficient to sustain the verdict under state standards. Rook aged behind bars. His hair grayed, and arthritis settled into his hands from years of industrial cleaning work. He taught himself to read case law in the prison library, poring over volumes of criminal procedure texts and taking notes on yellow legal pads. Other inmates dismissed him as a jailhouse lawyer, but Rook never stopped writing letters. He contacted the Riverbend Innocence Clinic, a nonprofit staffed by law students and supervising attorneys who reviewed post-conviction claims. Most of his letters went unanswered. The clinic received hundreds each year and could take only a handful of cases. But in 2019, a second-year student named Ember flagged his case during a case review seminar. Ember noticed 2 details buried in the trial record. The undisclosed sentencing agreement for Jasper, hinted at in a footnote of an unrelated appellate opinion involving the same prosecutor, and a notation in the original evidence log indicating that a buccal swab taken from the victim's neck had been stored at the Arcadia Evidence Facility, but never tested for DNA. The lab at the time of trial lacked the sensitivity to process touch DNA. The technology required larger samples, and degraded or low copy number DNA could not be reliably amplified. But by 2019, techniques had advanced dramatically. Short tandem repeat analysis, or STR, could now extract profiles from nanogram quantities of cellular material. Probabilistic genotyping software could interpret complex mixtures that earlier methods would have deemed inconclusive. Ember brought the case to Attorney North, who had left the public defender's office after burnout and joined the clinic as a staff attorney. North remembered Rook's case vividly. It had haunted her for years. The nagging sense that something had gone wrong. North filed a post-conviction DNA testing motion under the state's newly amended statute, which allowed defendants to petition for testing of biological evidence that had not been examined at trial, and that could produce exculpatory results material to the conviction. The motion argued that if the buccal swab contained DNA from someone other than Rook or the victim, it would directly contradict the state's theory that Rook acted alone and had physical contact with Linden during the attack. North attached affidavits from forensic experts explaining that buccal swabs from a victim's neck often capture epithelial cells from an assailant's hands during manual strangulation or restraint. and that such samples, if properly stored, could yield reliable profiles decades later. The state opposed the motion vigorously. Assistant District Attorney Flint, who had inherited the case from the retired Slate, argued that the swab was likely degraded after more than 2 decades in storage, exposed to temperature fluctuations and potential contamination. Flint also pointed out that even if a profile was obtained, it could belong to anyone. A paramedic who stabilized the body at the scene, a morgue technician who handled the remains, or even an artifact of secondary transfer. Flint cited case law holding that newly discovered evidence motions must show that the evidence would probably produce an acquittal on retrial, a high bar designed to prevent fishing expeditions. He argued that Rook had not met that burden. Judge Keystone, now in his 3rd decade on the bench and presiding over the post-conviction proceeding, reviewed both briefs and oral arguments during a preliminary hearing. North pressed the chain of custody issue, producing sealed evidence logs showing that the swab had been stored in a climate-controlled vault, transferred only twice, once from the medical examiner's office to the evidence facility, and once for an internal audit, and had remained sealed in its original packaging. She also highlighted advances in forensic science, noting that modern extraction kits and amplification protocols minimized contamination risk. After deliberation, Keystone issued a narrow order. The swab would be sent to Arcadia Laboratory, an accredited facility specializing in cold case forensics, for STR analysis using current best practices. If a usable profile was obtained, the court would hold an evidentiary hearing to assess its significance and reliability. 6 months later, on a humid morning in August 2020, North received a FedEx envelope from Arcadia Laboratory. She opened it alone in her office, hands trembling. The report, authored by forensic analyst Juniper, ran 14 pages and included electropherograms, graphs showing peaks at specific genetic loci, that told a clear story. The swab had yielded a complete male DNA profile, consistent across 16 STR markers, with a random match probability of 1 in 4 trillion in the general population. The profile did not match Rook, and it did not match Linden. Juniper had cross-referenced it against the state's convicted offender database and found a hit. Cray, a 46-year-old man serving a sentence in another state for armed robbery and sexual assault. Cray had lived in Riverbend in 2007, 3 blocks from Magnolia Park, and had a criminal history that included a prior charge, later dismissed due to witness unavailability, for assaulting a woman during a mugging in 2005. North's pulse raced as she read the supplemental materials. Cray's mugshot from 2007 showed a man with hollow eyes and a scar along his jawline. His arrest record listed violent offenses spanning 2 decades. He had been questioned by Riverbend police in 2007 about an unrelated assault but had never been connected to Linden's murder. North immediately filed a motion to vacate Rook's conviction, attaching the lab report and a supplemental declaration from Juniper explaining the testing methodology. Juniper's declaration detailed every step. Technicians had used a Chiagan DNA IQ extraction kit to isolate cells from the swab, amplified the DNA using a PowerPlex Fusion 6C assay, a commercial kit that targets 27 genetic markers, and analyzed the results on an Applied Biosystems capillary electrophoresis instrument. The profile met all quality control thresholds, including peak height ratios, stutter ratios, and heterozygote balance. The chain of custody was unbroken. Each transfer of the swab, from crime scene to evidence locker to lab, was documented with signatures, dates, and tamper-evident seals. Juniper also addressed the issue of contamination. The swab had been collected from an area of the victim's neck where saliva or skin cells from an assailant's hand would likely transfer during a struggle or restraint. The quantity of DNA, sufficient to produce a full profile, and the location made it highly probative of identity. Juniper noted that while secondary transfer, DNA carried on an object and then deposited indirectly, is theoretically possible, the amount and quality of the profile, combined with its anatomical location, made that scenario unlikely. She concluded that the profile most likely originated from direct contact between Cray and Linden during the attack. The state's response was defensive and procedural. Flint argued that the DNA could have been deposited innocently. Perhaps Cray had encountered Linden earlier in the day at a public location, or had touched an object she later touched. He emphasized that the presence of Cray's DNA did not affirmatively exclude Rook from involvement. It was possible, Flint theorized, that 2 individuals had attacked Linden, and that Rook had been convicted correctly for his role. Flint also highlighted a procedural hurdle. Under state law, newly discovered evidence must be material, meaning it bears on the defendant's guilt or innocence, and must be of such weight that it would probably produce an acquittal on retrial. He argued that North had not met that burden because the DNA alone did not disprove the state's theory. But North had more. After weeks of digging through archived police files, she uncovered a supplemental report that had never been disclosed to the defense at trial. The report, filed by Patrol Officer Reed, documented that Reed had stopped Cray for questioning near Magnolia Park on the night of Linden's death, approximately 2 hours after the estimated time of the attack. Reed had noted Cray's disheveled appearance, torn shirt, and visible scratches on his forearms. When asked what he was doing in the area, Cray said he had been visiting a friend and became agitated when pressed for details. Reed released him without taking a formal statement or photographs, a decision he later attributed to workload and lack of probable cause. The report had been filed in a supplemental binder that Prosecutor Slate had compiled, but never turned over to the defense, another Brady violation. North attached Reed's report to her motion, along with an affidavit from Reed, now retired and living in another state, confirming its authenticity and expressing regret that it had not been shared. Judge Keystone scheduled an evidentiary hearing for late November 2022. The courtroom filled early. Local reporters lined the back row, and Rook's daughter, Wren, sat in the front gallery, meeting her father's eyes for the first time in 2 years. The air was thick with anticipation. North called Juniper as her first witness. Juniper, composed and precise, walked the court through the lab's findings. Under North's questioning, she explained that the location of the DNA on the victim's neck, in an area consistent with manual restraint, strongly suggested it was deposited during the attack, not through casual contact. She displayed enlarged electropherograms on a courtroom monitor, pointing to the peaks that confirmed Cray's profile. On cross-examination, Flint asked whether Juniper could rule out secondary transfer. Juniper acknowledged the theoretical possibility, but reiterated that the quantity, quality, and anatomical location of the DNA made secondary transfer an improbable explanation. She also noted that the swab had been collected within hours of the attack, reducing the window for innocent transfer. Next, North called retired Detective Harbor. Harbor, now 71, walked slowly to the stand, his face etched with age and reluctance. North confronted him with the undisclosed sentencing agreement for Jasper, produced from state archives after a lengthy public records request. The agreement, typed on official letterhead and signed by Slate and Jasper's attorney, promised Jasper a sentence reduction in exchange for truthful and complete testimony against defendant Rook. Harbor admitted he had been present during negotiations but claimed he assumed defense counsel had been informed, a claim North challenged by presenting the trial record, which showed no mention of the deal. The courtroom stirred. Judge Keystone leaned forward and asked Harbor directly whether the agreement had been memorialized in writing and whether he knew it had not been disclosed. Harbor, his voice barely audible, confirmed both facts. North then introduced a sworn affidavit from Jasper, obtained after months of negotiation and the promise of anonymity. In the affidavit, Jasper recanted his trial testimony in full. He admitted he had fabricated the confession story after Prosecutor Slate coached him on details of the crime, information Jasper could not have known otherwise, such as the location of the stab wound and the fact that Linden's purse had been taken. Jasper stated that he had feared losing the sentencing deal if he refused to cooperate, and that he had lied under oath to save himself. The courtroom erupted in murmurs. Flint objected, arguing the affidavit was self-serving and inadmissible hearsay, but Judge Keystone overruled him, citing state rules that permit recantations by trial witnesses in post-conviction proceedings when corroborated by other evidence. North's final witness was Officer Reed. Reed, visibly uncomfortable, testified about his encounter with Cray on the night of the murder. He confirmed writing the supplemental report and explained that he had documented Cray's scratches and agitation, but had not pursued further questioning because he lacked specific information linking Cray to a crime. When North asked why the report had not been disclosed, Reed said he had submitted it to the lead detectives and assumed they would handle it appropriately. He expressed remorse that the report had been buried and stated that, had he known its significance, he would have insisted on follow-up. In her closing argument, North framed the evidence as a cascade of systemic failures. coercive interrogation that produced a false admission of presence, undisclosed deals that incentivized perjury, suppressed reports that pointed to an alternate suspect, and untested DNA that definitively identified the real perpetrator. She argued that Rook's conviction rested on a foundation of sand, and that the DNA profile, combined with Jasper's recantation and Reed's suppressed report, met the statutory standard for vacateur. She invoked the Supreme Court's holding in Brady v. Maryland, emphasizing that the prosecution's duty to disclose exculpatory evidence is not discretionary but constitutional, and that the cumulative effect of the violations had denied Rook a fair trial. Flint countered that the state's original theory remained plausible, and that the new evidence, while troubling, did not definitively prove Rook's innocence. He suggested that Rook and Cray could have acted together, though he offered no evidence to support the theory. His arguments sounded hollow. Even Judge Keystone's questions during rebuttal suggested skepticism. After a 2-hour recess, Keystone returned to the bench and delivered his ruling from prepared notes. He found that the DNA evidence was material and exculpatory, that the Brady violations, both the undisclosed sentencing agreement and the suppressed patrol report, had deprived Rook of a fair trial, and that no reasonable jury, confronted with the totality of the new evidence, would convict Rook beyond a reasonable doubt. The court vacated Rook's conviction and dismissed the charges with prejudice, meaning the state could not retry him. The gallery exploded in applause. Wren sobbed openly, and Rook sat motionless, staring at his hands. Rook walked out of Granite County Correctional Facility on a gray morning in February 2023, carrying a single cardboard box of belongings, a few books, letters from his mother, and the legal pads on which he had drafted his appeals. Wren waited at the gate, and they embraced in silence, cameras clicking behind them. Rook's first meal as a free man was takeout from a diner he remembered from his 20s. The building had been demolished years earlier, so they ate in a motel room instead, the food tasting like cardboard. Adjusting to life outside was jarring. Rook had no driver's license, no credit history, and no work experience from the past 23 years that an employer would recognize. The world had changed: smartphones, social media, streaming services, and he felt like a ghost walking through a foreign land. The state's wrongful conviction compensation statute entitled Rook to $50,000 per year of wrongful incarceration, calculated from the date of conviction to the date of release. $15 million in total, but the payout required a separate civil petition, a lengthy process that involved proving, by clear and convincing evidence, that he had not committed the crime. North helped Rook file for a certificate of innocence, a legal document that formally clears the record and is necessary for employment, housing applications, and restoration of civil rights such as voting. The petition included the DNA evidence, Jasper's recantation, Reed's suppressed report, and a detailed timeline showing that Cray's presence in Riverbend and his encounter with police on the night of the murder corroborated the forensic findings. The certificate was granted in June 2024, but the compensation payment did not arrive until December of that year, nearly 2 years after Rook's release. In the interim, he lived with Wren and her family, sleeping on a pull-out couch and attending therapy sessions funded by a nonprofit that supports exonerees. The psychological toll was immense. Rook suffered from nightmares, hypervigilance, and an inability to trust authority figures. He avoided crowds and flinched at loud noises. Therapists diagnosed him with complex post-traumatic stress disorder, a condition common among long-term prisoners, especially those wrongfully convicted. Meanwhile, the case against Cray closed a loop. After the DNA match became public, cold case detectives in Riverbend reopened the investigation into Linden's murder and interviewed Cray in prison. Initially, Cray denied involvement, but when confronted with the DNA evidence in Reed's report, he agreed to a plea negotiation. Facing the possibility of the death penalty if the case went to trial, Cray confessed in exchange for a sentence of life without parole. During interviews, Cray admitted he had been high on methamphetamine the night of the attack and had followed Linden into the park intending to rob her. When she resisted and screamed, he stabbed her and fled, discarding the knife in a storm drain that was later paved over during road construction. He burned his clothing in a trash barrel behind his apartment. Cray said he had watched news coverage of Rook's trial from a distance, relieved when the jury convicted someone else, and had never expected the DNA to surface decades later. The case left scars on Riverbend's justice system and sparked calls for reform. The district attorney's office launched an internal review of cases prosecuted by Slate, who had retired in 2015 after 30 years as a prosecutor. The review identified 12 other instances of potential Brady violations, including undisclosed witness deals and suppressed police reports. The state bar opened an ethics investigation, but Slate could not be disbarred posthumously. He had died of a heart attack in 2020. His legacy, once celebrated, was tarnished, and the courthouse where he had tried hundreds of cases removed his portrait from the Hall of Honor. Detective Harbour gave a single interview to the Riverbend Gazette, expressing regret but defending the original investigation as reasonable given the information available at the time and the pressure to solve a high-profile case quickly. His comments drew criticism from wrongful conviction advocates who pointed to the coercive interrogation, the reliance on a jailhouse informant with a clear motive to lie, and the failure to pursue alternate suspects like Cray. Harbour declined further interviews and moved out of state. The case also prompted legislative reform. In 2024, the state legislature passed the Riverbend Accountability Act, a comprehensive package of criminal justice reforms. The act mandated audio and video recording of all custodial interrogations in felony cases, required open file discovery in which prosecutors must disclose all evidence to the defense, regardless of its perceived relevance, and established automatic preservation of biological evidence for the duration of any sentence. The act also expanded the state's compensation statute to include not only financial restitution, but also funding for mental health services, job training, housing assistance, and expungement of all records related to the wrongful conviction. Advocates hailed the reforms as a model for other states, though critics noted that they came too late for Rook and the hundreds of others wrongfully convicted before the changes took effect. For Rook, vindication did not erase the years. He attended his granddaughter's 3rd birthday party in 2024, sitting quietly at the edge of the backyard while children played, their laughter a foreign sound. Wren told a reporter that he rarely speaks about his time inside, that he keeps the vacateur order in a frame on his kitchen wall next to a photograph of his mother, and that he spends hours each day reading or walking alone in the park. Not Magnolia Park, which he avoids, but a different one across town. At dawn most mornings, Rook sits at the kitchen table with a cup of black coffee, the house silent around him, and stares at the 2 images on the wall. One a legal document that returned his name and freedom, the other a face he will never see again, the woman who believed in his innocence until her last breath. That tableau, suspended between loss and release, captures the arithmetic of wrongful conviction. Justice, when it finally arrives, is always partial, always late, and can never restore what was taken. If this case has shown you how fragile the system can be, and how lives can be shattered by failures at every level, investigation, prosecution, trial, and appeal, then share it with others who need to understand. Follow along as we continue examining the forensic and legal mechanisms that protect, and sometimes fail, the innocent.